Hello and welcome to part 3 of this talk about machine learning at the EPO. My name is Sam Jones. I'm a UK and European patent attorney at Gill Jennings Every. And in this part of the talk, we're going to think about the types of things that you might want to be talking to inventors about and the considerations that you might have when you're thinking about whether or not to file a patent application to an invention that involves machine learning. So here's a set of things that I'm always thinking about when discussing machine learning inventions with inventors. And first of all, it's inherently hard to detect infringement of machine learning claims that include algorithmic details. And so this is specifically type 1 and type 2 machine learning inventions that you can find more out about in part 2 of this set of talks. And the reason for this is that quite often, a competitor who is implementing machine learning is not going to give you access to the machine learning component whatsoever. You know, it could be implemented as, say, a software as a service model where the machine learning algorithm is hosted in the cloud. So all you can see as a sort of outside user is a query being sent and a response being provided. You have no idea how the machine learning algorithm operated in order to produce that response, and therefore you don't know if you have a claim that requires the machine learning algorithm to do certain things. You don't know whether your competitor's machine learning algorithm is actually doing those things, and so you don't really have an ability to determine infringement without going to a lot of effort, potentially gaining access to proprietary information, which can be very, very difficult or indeed impossible. So that's something definitely to keep in mind when you're considering whether or not to file a patent application, because if you have a type 1 or type 2 machine learning invention, it may be that there's not any reasonable likelihood of you ever being able to enforce that patent. And so therefore, the best way to protect that invention might be to keep it secret. Of course, there are other reasons for filing patent applications other than to sue other parties. It may be that perhaps you have an investor who's very keen to see that you've got some form of registered IP, in which case, although you may have no intention of ever asserting your patent against somebody else, the very fact that you have a granted patent could be helpful. Equally, it may be useful as a deterrent, because competitors who see that you have a patent may not want to take the risk of operating within it, even if they know that it could be difficult or impossible for you to detect such operation. And so without you even knowing it, you may actually be deterring competitors from encroaching upon your invention. So it's not to say that if you have a type 1 or type 2 machine learning invention, you should never file a patent application, but it is to say that it is worth considering what value a patent would represent to you in those circumstances, and to weigh up whether or not it does justify the time and effort spent in preparing a patent application. Because something to keep in mind as well is that sort of the flip side of the difficulty of detecting infringement is that it is typically relatively easy to keep the details of your machine learning algorithm secret if you wish to do so. Whereas in a lot of other fields of technology, typically things that are being generated, as actual consumer products, it's very difficult to keep your invention secret because, of course, a competitor can purchase one of your products and take it apart and have a look how it works. So that is an advantage of having machine learning inventions, in that if you do think the best thing to do is keep them secret, it's typically possible to do so. But if you're in a circumstance where your machine learning algorithm is in fact going to become part of the public domain, such as, for example, your inventors are looking to publish papers about it, or you're going to need to give customers access to it, or for any other reason, that may swing the balance back towards, actually, yes, it is worth filing a patent application here because details of the algorithm are going to become public anyway. Another thing to think about for machine learning inventions, in fact, indeed, computer implemented inventions in general, is infringement jurisdiction. And the reason to think about this is that patents are inherently a territorial right, in that a patent will cover activities only in the jurisdiction in which it's been registered. So for traditional inventions, that was an easy thing to think about, because you would be looking at, well, which jurisdictions are my markets in, where my products are going to be sold, which jurisdictions am I going to make my products. But with computer implemented inventions and machine learning inventions, indeed, this is a more complicated thing, because you are now talking about a computer system that may well be distributed across many different jurisdictions. And indeed, different aspects of the machine learning process can be performed in different geographical locations. So, for example, the training of the machine learning algorithm may take place in a completely different jurisdiction to the use of the algorithm. And indeed, the use of the algorithm could be in the cloud. And so your customer or end user could be again in another jurisdiction. So you really need to think about what is this patent application going to cover in terms of the invention, and which jurisdictions is that aspect of the invention going to be taking place. So you may be asking yourself questions, where is the data center that is going to be performing this machine learning algorithm? That's actually more relevant, say, than where your customers may be located. Another thing to keep in mind specific to machine learning algorithms is that ownership of training data is separate from ownership of the trained models. So, you can imagine a situation where you're developing a machine learning algorithm and you're having to rely upon proprietary data provided by some other third party in order to train your algorithm. So it's important to keep in mind in that situation that the third party is likely to retain ownership of that training data. And so you need to be sure that in the future, where you may need to, say, retrain your algorithm, you're going to be able to have access to that proprietary database. That's something that you can think about when you're negotiating agreements with data providers. Equally, if you have a set of data that really people would like access to in order to train their models, then that's a valuable asset, because without your data, potentially models can't be trained in order to provide the level of accuracy that's required. And so in that case, it's definitely worth thinking about whether there's an opportunity to license access to your data, or have some other type of framework in which you can operate where you can monetize your training data. Equally, if you own some training data, the ideal situation, of course, is that you have some ability to reach through to own or co-own models that are trained on that data. So depending on your commercial environment, that may be something that you can negotiate. So it is definitely worth thinking about. Then finally, another consideration, and this is more on the sort of patent law side, is that the EPO has indicated that buzzwords are not welcome in machine learning applications. They say it's best to refer to things like classification and machine learning algorithm, rather than perhaps terms that are a bit more vague, or terms that are less technical, things like AI, intelligent prediction, AI powered, those type of things that you might see sort of more generally in this space. So I think the impression that I've had from speaking with EPO examiners is that they find those types of terms annoying, because from their perspective, they're only interested about what are the technical features of these inventions. And so buzzwords obscure that to some extent, which means that you're making their job harder when they're having to work out what it is your invention is actually doing. So that's one for anyone drafting patent applications in this space. Then I've got here on this slide the type of things that I'm thinking about when talking to a client about a machine learning invention. And I go through this process mentally to make sure that I'm focusing the discussion on the right area, so that it's the most productive it can be. The first thing I'm thinking about is some aspect of the machine learning algorithm novel, and if not, then in fact there's probably no invention to be made. Sorry, no filing to be made here, because we're probably talking about a type 3 machine learning invention, which is just using a machine learning algorithm off the shelf without any sort of modification to perform some sort of operation in the context of a larger system. But one thing I would be asking in that case is, okay, so the machine learning algorithm, that's not the invention here, but is there something else related to it that is, in fact, something that's novel and inventive, because that in its own right could be patentable. If there is something like that, then there may well be a case for drafting and filing a patent application. But what we want to make sure in that case is that we focus on whatever aspect we're relying upon to give us novelty and inventive step, and not on the machine learning algorithm. Because frankly, details of the machine learning algorithm are a waste of time in this situation, because they're not going to help you with patentability. And so probably I would be drafting claims that don't mention machine learning at all. So they may say something along the lines of a component to generate a prediction, something like that, or a classification component, rather than saying a machine learning algorithm. And I'd probably in the description be devoting only a paragraph or so to discussion of machine learning algorithms. So I'd probably have a statement along the lines of, in one embodiment, X is performed using machine learning. And that should be enough, because machine learning, it's not the invention, so it's not really important to go into the details of it. And one thing you really want to avoid in this situation is restricting your claims to any specific details of the machine learning algorithm. And the reason for this is to do with detection of infringement. So if you think of a claim that's limited to a machine learning algorithm just generically, okay, that's probably something you can find out about from, say, a competitor's press releases, because they're probably going to mention the fact that their offering is involved using AI, because it's quite a nice sort of marketing buzzword. So you're probably going to know, yes, they are using machine learning, just simply from looking at their website or something like that. But as soon as you go one level detail lower, and it really is quite a sort of trivial level of detail lower, where you say something like, instead of saying using a machine learning algorithm, you say, oh, I'm using a support vector machine, or I'm using an artificial neural network. While that's not going to help you whatsoever in patentability terms, but it's made your job of trying to detect infringement a hell of a lot more difficult. And the reason for that is that you now need to know not just that your competitor is using machine learning, but the specific type of algorithm they're using. And that is something that is perhaps far less likely to appear in their press releases. So you're now suddenly, you've made your task much more difficult when you're trying to detect infringement without any sort of gain on the patentability side. So that's something I'd very much avoid for type 3 machine learning inventions. So returning to this flowchart, let's say we're now in the case where some aspect of the machine learning algorithm is novel. And so the question we need to answer now is whether this novel aspect offers any sort of advantages in the context of a technical system. And the reason for that is that if we're going to need technical character as one of the things that is required for the EPO to grant us a patent. And if we don't have technical character, then no matter how innovative the machine learning algorithm is, we're not going to get a patent granted for it. So if we're in the situation where the novel aspect of the machine learning algorithm does not offer any sort of advantage in a technical context, we're going back to the position of it's unlikely that there should be a filing made here. Instead, probably the best option is to keep details of the machine learning algorithm secret if possible, and just to carry on like that, because the chance of getting a patent granted in that case is quite low. This is, of course, assuming that there's no other aspect of the invention that is in its own right patentable. If there is some other aspect, then we're back to the same considerations as with a type 3 invention, where you're just going to want to focus your patent application on that novel aspect, and really machine learning takes a back foot in that case. Going back to the question about the technical system, if the machine learning algorithm does in fact offer an advantage in the context of a technical system, then that's when we're really considering filing a true machine learning patent application. And this would be the type 1 or type 2 inventions, which are applied in a technical context. So in that case, you can consider filing a patent application. You're going to definitely want to make sure that you describe and claim your machine learning algorithm in a technical context to make sure that you give it the technical character it needs. So that could be in the context of a technical system, and you'll see from part one of this talk that an example of that is a controller for an X-ray apparatus, or it could be the machine learning algorithm operating on technical data, such as audio data or image data. So you want to, and then a consideration there is, if I have a patent limited to that technical context, is it of sufficient commercial value? And the answer hopefully will be yes, but in fact, you may think, no, actually, there's so many applications for this algorithm, some of which are non-technical that you know, we as the inventors would want to use it for. Then you may have an argument, even though you have a reason to think that you could get a patent granted, you may actually want to keep details of the invention secret for that reason. If you do decide, yes, we want to go ahead with this, then you'll definitely need to include details of the machine learning algorithm that give rise to the advantage in your patent application. So you might be giving details of the feature vector, you might be giving details of the training method or the hyperparameter selection, or whatever it may be that has enabled your machine learning algorithm to be better than what is already known. And you'll want to focus your description on those aspects particularly, rather than providing details sort of all aspects of your machine learning algorithm. Because frankly, details on things that are not related to the novel aspect, that it's not going to help you from a patentability perspective. So it will just be providing additional information to competitors when the patent application publishes, and B, lengthening the time it takes to draft your patent application, and to it may be trickier to prosecute if you have a particularly long description as well. And as the final bullet point there, as I mentioned earlier, it's always a consideration as to whether you want to keep this secret rather than having it go into the public domain. Machine learning algorithms are somewhat unique in that it is relatively easy compared to a lot of inventions to keep them secret. So in a lot of cases with other types of invention, you know, the answer to that would be, well, you know, it's going to go into the public domain anyway when I market my product. But for machine learning, you really can actually keep your algorithm secret, and so and still operate commercially as you wish. And so that is a very relevant consideration for even when you get to the bottom of that, the left-hand side of that figure. Right, and now I have a slide on discussions with inventors. And these are the type of things that I'm always trying to think about when I'm talking to an inventor of a machine learning invention. So the first thing I'm trying to do is classify the inventive concept. I want to know which type of machine learning invention is being dealt with, because that's going to affect the type of things that I'm going to focus on when I'm discussing it with the inventor. You know, for example, if I identify this is a type 3 invention, then I'm actually not really going to want to talk about the machine learning at all with the inventor. And I'm really going to want to find out whether there's some other aspect of the invention that we could possibly rely upon for patentability. In contrast, if it's a type 1 invention, then I'm going to want to know all of the details of the machine learning algorithm, and indeed how those can be mapped to some sort of technical context. So that's a completely different discussion from what perhaps at the very beginning appeared to be a very similar thing. So that's what I would always try and do to start with. Then checking for technicality for all types of machine learning invention is important, because of course, if you don't have technicality, no matter how good the machine learning algorithm, you're not going to be able to get a patent at the EPO. And one of the things that is useful that I discussed in part 1 of this talk is to do a sort of thought experiment where you think about whether the inventive concept for the invention came from a business, i.e. non-technical person, or a technical person. And that can help you to determine whether or not the machine learning algorithm is being employed in a technical context. Then I'm also going to think about data, because this is something that comes up quite a lot. You know, we're being asked, you know, do we need to include a training data set, for example, or other types of data, you know, in an example of the machine learning algorithm code, things like that. And in fact, no, we don't need to typically include that level of detail, because the EPO is typically happy to take us at our word, where we say in the patent application as filed, some sort of advantage statement about why the machine learning algorithm offers some sort of improvement. So, if you were, say, working on an image processing machine learning algorithm, you probably wouldn't need to provide any training data for it. What you could say is that, we found that if we train on this set of features, our algorithm is better at recognizing faces. And you may have a reason why you think that is, and you could include that as well, but not necessarily. You could just make that statement without supporting it to too much level, and that could be enough. The patent office will tend to take us at our word. So that's quite useful, because it means that you're not going to need to be giving away things like actual training data sets, and you're also not going to need to give too many low-level details of other types of things that, say, comparative data or comparative analysis with other types of machine learning algorithm, which could be time consuming to generate and indeed lengthy. So that concludes part 3 of this talk. If you'd like some more information, please do visit our website, send me an email if you have any questions, and I'll do my best to answer them, or connect on LinkedIn and I can answer your questions that way.